test that the document room is having about President's Day. It's a trivia about presidents. There's 15 questions. You may use your phones if you would like to. You would turn it into them, and there's a prize at the end. But it's just kind of fun way to be celebrating this month when we have President's Day, when we will be working, by the way. Okay. All right. So again, welcome everybody. We're going to go ahead and have two bill hearings. We will be working House Bill 2061 at the end of our bill hearings, just so you know. I also want to welcome Representative Speaker Pro Tem Carpenter and hope that Representative Bourgeon feels better, but thank you for filling in for us today. We appreciate that. Okay, I'm going to open the hearing then on House Bill 2182 and ask our reviser, Jason Thompson, for a bill brief. Yes. Yes. Right.
Yeah. Thank you, Madam Chair. As you mentioned, Jason Thompson, Revisor's Office. I should have the bill brief for House Bill 2182. The bill prohibits a sheriff from charging a fee for service of process for proceedings under the Protection from Abuse Act and the Protection from Stalking, Sexual Assault, or Human Trafficking Act. The amendment is to KSA 28-110. That's the statute that gives a fee to the sheriff for serving, executing, and returning any process. You'll see under current law there in lines 13 and 14 that the sheriff can charge a fee of $15 for serving process. The bill adds a provision right after that that says an exception to that rule: no fee shall be charged for serving, executing, and returning process for a PFA, that's protection from abuse, or a PFS is what it used to be called, but now it's PFS-SAHT or something to that effect, Protection from Stalking, Sexual Assault, and Human Trafficking Act. That is the peanut of the bill. It would take effect on July 1st of 2025. And I'll remind you that last session, this committee, I believe, put similar language in Senate Bill 265 and sent it out of committee, but it did not come up above the line, and it was removed from the calendar later on. I believe that's the procedural history. So it will look familiar to some of you.
Okay, thank you, committee. Do you have any questions for Mr. Thompson? Okay, thank you so much. All right, I'll go ahead and call our proponent, Michelle McCormick from the Kansas Coalition Against Sexual and Domestic Violence. Thank you for being here.
There we go. Good afternoon, members of the committee. Madam Chair, I am Michelle McCormick. I'm the Executive Director of the Kansas Coalition Against Sexual and Domestic Violence, which is a nonprofit organization in our state that provides services and support to the 25 programs in our state who do direct service for victims and survivors of domestic and sexual violence. Thank you so much for the opportunity today. As Jason mentioned, what we're bringing to your attention is the need to clarify statutorily that there not be a process service fee. A couple of reasons we bring that forward. Of course, we don't want there to be any barrier for victims and survivors to getting support. And even though a $15 fee may seem nominal, it could very well be the thing that would prevent somebody from accessing this tool for their safety. And so that's one reason. Also, another important reason is that our state receives federal funds, the Violence Against Women Act funds, and in order to qualify for those Stop Violence Against Women Act dollars, we have to certify certain conditions, and we attached the certification criteria to our testimony, so hopefully you have that. But one of the criteria is that there not be a process service fee in order for these orders. And so basically that's what we're asking for, is your consideration around making sure that this tool is still available to victims and survivors, and that those important grant dollars are still able to support our programs. So that's the gist of it. I'd be happy to answer any questions if you have those.
Okay, thank you. Committee, do you have any questions for Ms. McCormick? Representative Barrett.
Thank you, Madam Chair, and thank you for coming to committee today. And just to clarify, a lot of sheriffs are doing this. Maybe there's a few out there that don't. But this is just clarifying that language, saying that, hey, we're not going to charge you for trying to protect yourself from being victimized, correct?
Yeah, thank you, Representative. You're correct. Largely, this isn't a significant issue. Most sheriff's offices in our state customarily do not charge the fee. In the cases where it has happened in the state during my time in advocacy, it's been able to largely be addressed through conversation and those discussions about the impact. But it does occasionally happen. It does crop up. But we have worked with our partners in law enforcement, Mr. Klump's behind us, who has looked at the bill and reviewed it. And by and large, this wouldn't have significant impact as far as funding to sheriff's offices in our state, from what we understand.
Thank you. Sounds like a good bill. Thank you, Madam.
Thank you so much. Any other questions, committee? Okay. Oh, I'm sorry. Representative Barth.
Thank you, Madam Chair. Just curious on how someone would file a PFA and how easy do they make it other than the fee? Thanks.
Yeah, absolutely. Thank you for your question, Representative Barth. There have been a lot of improvements actually in my lifetime. I've been doing victim advocacy for over 25 years in our state. And now there is much more ease because of access to things like the protection order portal, which is really hard to say. But the portal that's run by the Office of Judicial Administration makes that accessible to folks through their cell phones, online, but also all of the victim advocacy agencies provide support to assist survivors to do that. If they want to do it in person in their district court clerk's office, they're able to walk in and do that as well. And so there are quite a few opportunities for folks to consider that option.
Okay, thank you. Any other questions? Representative Ward.
Thank you, Madam Chair. Are you telling me that if we don't put this wording in, that it could hinder you from getting funding?
I think that's a possibility. There is a requirement, a list of requirements from the federal government in order to qualify for those grant dollars, and this is one of them.
Okay, thank you.
Great, thank you. Any other questions? Okay, thank you so much. We appreciate you coming. Committee, also, as you will see, there's written only testimony from Mr. Ed Klump, pretty much saying exactly what Representative Barrett brought up. And so please take a look at his testimony also. And do we have any opponent or neutral testimony? Anyone want to say anything? Okay, thank you so much. We will close the hearing then on House Bill 2182. And we will open the hearing on House Bill 2183 and call again on our advisor, Jason Thompson, to give us a bill brief.
All right. Thank you again, Madam Chair. Again, Jason Thompson, Revisor's Office. House Bill 2183 briefly includes any photograph, film, video picture, digital or computer-generated image or picture that has been created, altered, or modified by artificial intelligence or any digital means in the definition of a visual depiction for certain criminal offenses. The bill brief gets into those offenses a little more specifically. I'll try to hit the high points here. Section 1 amends KSA 21-5510. That's the crime of sexual exploitation of a child. You'll see the change in subsection A2 on page 1. Expands the conduct that's prohibited by this section to include possessing a visual depiction of a child under 18 years of age, shown or heard engaging in sexually explicit conduct with intent to arouse or satisfy the sexual desires or appeal to the prurient interest of the offender or any other person, regardless of whether an actual child under 18 years of age was involved in the creation of the original image. It's that last clause, the regardless clause, that is added. So an actual child does not need to be involved in the creation of the image. And then in subsection D5, which you'll find on page 2 and then on to page 3, you'll see the definition of visual depiction that is the key to some of those elements is also amended to include the photograph, film, et cetera, that I mentioned before, created in whole or in part, altered or modified by AI or digital means, to appear to depict or purport to depict a child engaging in sexually explicit conduct. So that's what's added to the definition. Section 2 then does a similar change in KSA 21-5611. That's the crime of unlawful transmission of a visual depiction of a child. You'll note that in subsection G, where the definitions are, that section also applies to KSA 215610, which is the crime of unlawful possession of a visual depiction of a child. And those of you that were around a few years ago know that these two crimes were sort of created to deal with the situation of images being possessed or transmitted by folks that are 12 or more years of age, but less than 18 years of age, and the offender is less than 19 years of age, right? So these are peers typically, and these are the two crimes that relate to those groups of folks. And this adds the definition of visual depiction that we just talked about. So the photograph, film, generated image, et cetera, altered or modified to appear to depict or purport to depict a child engaging in sexually explicit conduct. So a similar definition as what's in 5510, but needed to be replicated here in 5611, so that's also covering 5611 and 5610. And then the last crime in the bill is section 3, that's KSA 21-6101, that's breach of privacy. Specifically, it's subsection A8, and those of you that have been around remember this was the one that was added a few years ago, colloquially called like the revenge porn subsection here, right? This is disseminating photograph, image, et cetera, of a person over 18 years of age with the intent to harass them, intimidate them, et cetera. And the person did not consent to that dissemination, right? So that's the current law. And what's added is that this will include those modified images that appear to depict or purport to depict that identifiable person, regardless of whether the identifiable person was involved in the creation of the original image, right? So taking something that looks like that person and just disseminating it is the same as actually taking the photo and then disseminating it. That's the idea there. I think that covers the 3 crimes in there, expanding the elements on a couple of them, adjusting the definitions in all 3, and then it would become effective on July 1st if adopted. Happy to answer questions if I can.
Okay, thank you. Committee questions, Representative Carmichael.
Thank you, Madam Chair, and thank you, Mr. Thompson. I appreciate your fine brief of this legislation. At page 1, I do appreciate you drawing the contrast that this bill deals with not only actual depictions of living people or even dead human beings, but also things that are just fabricated by whatever type of a device. That's important. We'll get to it. But my real question is at page 2 and the top of page 3 of the bill in the definition, of visual depiction. And it looks like that the language that we are adding at commencing at page 2, line 41, 42, 43, and continuing into page 3, it looked to me like we're just duplicating to a large extent the same language twice. The first sentence at line 41, visual depiction means any photograph, film, video, picture, digital or computer generated image or picture, whether made or produced by electronic, mechanical, or other means. And then if I'm reading that, we're going to then put in the statute visual depiction, which is the same thing we just defined in the sentence before, includes the same things that we just described in the statute as it stands now, and then adds after computer generated image or picture that has been created in whole or in part, altered or modified by artificial intelligence or any digital means to depict or depict a child. Is there a reason that we use the same words twice? And maybe this is just a drafting preference, or maybe there is an intent here to define visual depiction twice with the same words over and over. Can you help me a little bit with that drafting element?
Sure. Madam Chair and Representative, some of it is a bit of drafting preference, but the ultimate difference is the second half of the definition. So it does begin the same way because I wanted to make sure it echoed the same kinds of images or pictures. So I locked in on that phrase. And then instead of the whether made or produced by electronic, mechanical, or other means that's in the current law, it's created in whole or in part, altered or modified by AI or any digital means. And then the real key is the very final clause, the to appear to depict or purport to depict a child. So the replication is to make sure that it's specific to what's already there, but then differentiate the second piece. So a little bit of drafting preference, but I think it does have meaning.
My second question, with your leave, Madam Chair. I'm trying to figure out what the difference is between the phrase, and we're the same part of the bill, what the difference is between at line 42, page 2, digital or computer-generated image or picture, whether made or produced by electronic, mechanical, or other means, and the words we see at the top of page 3, line 3, line 2, modified by artificial intelligence or any digital means to appear to depict or purport to depict. That part of it, I don't see that there's a difference. It looks to me like the current language is broad enough to encompass artificial intelligence or digital means. Are you tracking? And I'm trying to understand what we're doing that is different by specifically saying AI and digital means when we already have electronic means. Can you help me with that? What additional conduct are we attempting to proscribe?
Madam Chair, Representative, part of the issue is that we are adding language that our law already covers part of. I recognize that we currently cover electronic, mechanical, or other means. So in some ways, we do already cover images that are created by AI or other digital means. I think that's accurate. That is a pretty broad phrase. So the goal of what was brought to me was to make sure that we included altered or modified by AI or any digital means. I could have altered the current language a little bit more and maybe merged them together a little bit better. But like I was mentioning, I think the real key is the final clause of the new language, the to appear to depict or purport to depict. That's what's kind of, I don't want to say missing, but the proponents will say what's missing from the current law is potentially that appearance of or purported depiction of the child. That's maybe what they were going for more, and the other part was more my drafting preference, trying to merge them together.
Madam Chair, I do recognize that the ending clause is different, but my concern is that we already have electronic, mechanical, or other means in the statute. Now we specifically say AI and digital means, and the legislature is presumed to have meant something different than the existing law by the enactment. And I'm worried about the collateral impact this might have in other statutes that already prohibit things by electronic and mechanical means. Does that mean AI prohibitions are only for the purpose of this statute? I'm not expressing that clearly, but that's why I ask. That's my concern. Thank you for your patience.
Okay, and maybe we'll be able to speak to some proponents about that too. So, okay, any other questions, committee? Okay, thank you, Jason. We appreciate it. Okay, I would like to call Mr. Mike Kage up, the DA of Shawnee County. Welcome back to committee.
Good afternoon, Madam Chair, members of the committee. Appreciate the opportunity to speak in favor of this bill. And you already have my written testimony, so I'm going to jump straight to the objections, the why questions, why are we here, and some of the things I've seen in prosecuting sexual exploitation of a child cases as it currently stands under the law. So a common argument we receive in these cases is this is a artistic representation. It's protected by the First Amendment, right? And so this is something, it's a tussle we go through with defense. It's something that has been litigated through the courts at the state and federal level. And the answer is clear. Child sexual abuse materials are not protected by the First Amendment. So if something is protected by the First Amendment, by definition, it does not fall within that umbrella. And as Representative Carmichael points out, this conduct is already prescribed. So what are we trying to do here? We're attempting to modernize the definition. AI is exploding. I'm sure you're all aware of that. This is the first time I have testified on a bill where AI was a part of it. I guarantee you it will not be the last. So we're really on the front end of this thing. And I believe this bill is absolutely necessary to protect our kids, to protect our kids from those who would commit sexual abuse upon them. So what we know is right now, CSAM materials are used to groom children. And AI CSAM materials are no different. They're also used to groom children and to normalize and desensitize that kind of sexualized behavior, which is what the offender wants.
What did you say? What kind of materials?
Sorry, CSAM stands for Child Sexual Abuse Materials.
Okay, thank you.
We used to call it child pornography. When I first started as a prosecutor, I think someone realized along the way that by definition, what we're looking at is not pornography, it is the sexual abuse of a child. Right? We're talking about videos and images where a child is being graphically raped. Right? There's no way to look at that and put it in the same bucket as something that is created between consensual adults. And so CSAM, I apologize, it's something that's used frequently now within law enforcement circles. So another common objection someone might raise to a bill like this, we're not talking about real kids, right? We're talking about a made-up computer kid. So what's the big deal? Who cares, right? And I understand on its face why someone would ask that question. But the technology that exists today can take any of your pictures and can morph it into whatever they want, right? So if somebody wants to go tonight and create a graphic video of me doing something, they can take a picture, they could take video from this hearing, plug it into their model, and they could generate that and send it out. And you may not be able to tell the difference. And that's, to me, that's a horrifying thought, especially for a kid who may have to live through that. And the other part of this, oftentimes in these cases, we identify the materials as CSAM materials, right? We clearly know this is a child, maybe the age of 10 to 14 years old, and they have been raped, and we have the video evidence of this rape, but we cannot identify the child, right? We don't know where that child is. We may not be able to find that child. We can still prosecute the offender who's possessing that material. And so this argument about whether or not it's a real kid, sometimes we don't know. And anymore, we're not going to be able to tell the difference a lot of times. And this covers that. This allows for it. This bill does not target artistic representations. It's not a free speech issue. This bill is narrowly tailored to deal with non-consensual or exploitative materials. And the final thing I want to leave you with is this. I have also heard people say, well, they're just looking at the materials. They're just watching the video. They're not touching kids. What's the big deal? Again, I've heard that too. So there have been a lot of studies that draw the correlation between offenders who possess these types of materials and those who actually go and contact children and actually commit what we call contact offenses. And I talk about this in my written testimony, but I want to cite one specific study. And this is published in 2009 in April in the Journal of Family Violence, Volume 24, Issue 3. It's called the Butner Study Redux. It was a report of the incidence of hands-on child victimization by child pornography offenders. What this study found is they asked the offenders who were going through treatment, they had them self-report. And what it found is that 85% of the offenders in this study self-reported as having had prior contact offenses with children. Meaning by the time they were in that study, and these aren't people who are convicted of crimes, okay? I'm talking about something else. I'm talking about people who are getting treatment and self-reporting, yes. Almost all of us have done this. And so that's why bills like this exist. That's why the current law prescribes this conduct. And that is why it has my full support. I'm happy to take any questions. Thank you.
Okay, thank you. I do think we have a little bit of time, so I'll go ahead and ask questions of each proponent as we go along, if that's okay with you. Committee, do you have questions? Representative Williams and then Carmichael.
Thank you, Madam Chair, and thank you for your testimony. I am curious, I don't think it was listed in your written testimony. I don't know if you can share, but have there been cases where there was possession of this type of material that's AI generated that you've seen and could not prosecute because of Kansas law?
Well, thank you for the question. I have not been in that situation yet. And it may be that law enforcement has simply not identified that case. But I foresee that happening, yes. But it has not happened in this jurisdiction, to my knowledge.
I have one more question. And I don't know if this is a Jason or a research question, or maybe you are familiar as well. But have there been other states that have implemented some similar language? And I'm looking at it from an AI business perspective. Is there any ramifications from the business that, you know, these AI companies that are generating these images that would be able to fall under then that new statute or this piece of legislation that would then penalize them as well?
That's a great question. And to answer the first part, it is my understanding that a plurality of the states at this point have either adopted legislation similar to this, accounting for the capabilities of AI in the CSAM space, whether they've adopted them or are currently in that process. I think there's a growing recognition around the country. This is an issue and they want to get ahead of it. The second part of your question, I do not know. I do not know right now what the potential impact would be on any of the many companies that engage in AI generation. That's a great question. Thank you.
If I can just say thank you for answering. I just think it is, you know, I would think from a business perspective, I don't know how many of these AI generated companies allow for this type of material to be produced. I would think a legitimate you know, AI company would not allow for this type of material, but I do think it'd be interesting to know, you know, what safeguards are in place already currently through a business aspect. But I appreciate you bringing this issue.
Thank you.
Representative Carmichael.
Thank you, Madam Chair, and I appreciate the representative's comments. The sad fact of the matter is that last year we passed legislation to try to keep minors from accessing porn sites. And unfortunately, we couldn't get them all. And now there's some places where there's some really sick stuff out there, including the kinds of things you're talking about. And yes, I have seen it. I, in fact, looked over the weekend knowing this was coming up, and there's terrible stuff out there. And so I hope people don't think that I'm here to defend child molesters, perverts, and degenerates. But Mr. Kagi, I do have some areas of concern. We're on the same page. You don't have to persuade me that child porn is a terrible thing, not only for the children who are depicted there, but that it also encourages aberrant behavior by folks who may start looking at it when they're children themselves. So I want to work with you, but I want to do it within constitutional parameters. And here's where my difficulty arises. I don't know if you've had a chance to see the testimony of Sergeant Swanson of the Kansas Internet Crimes Against Children Task Force that is being offered here on behalf of the city of Wichita.
I have not had that opportunity, Representative Carmichael.
The memorandum that we have is the written testimony of the Wichita Police Department, which was apparently directed to the sergeant's captain. It says, I'm wondering about the constitutionality of this. Seems rather broad. Below is an example of more specific language used in the South Dakota statute. And I'd invite you to look at that because it might be superior language. My research, though, has mine legislative research over the weekend and yesterday has failed to show me a case where we know that you can constitutionally prohibit morphed images of actual children. There's a good line of cases there. Of course, there's first Ashcroft, then Williamson, and a whole bunch of district court decisions that if it's an actual image that is morphed onto a different body or an adult body or whatever it is, that the child is a victim of porn, of child exploitation, and it's punishable. The public service announcement that we have in our materials, which says it's from the FBI, it talks again about morphed images of actual children putting a child's face on an adult body, etc. But I have been unable to find a case that says it is constitutionally permissible to prohibit the sick fantasies of child perverts in circumstances where it's purely their own creative, sick creative thought, as opposed to using an actual image of a child or morphing an image of a child. Can you lead me to such authority so that I can feel secure in supporting your bill?
Representative Carmichael, I do not have a cite for you on that today. I can certainly research that issue. What I said earlier was that the courts have clearly delineated child sexual abuse materials as being not constitutionally protected by the First Amendment. It may be that we are new enough in this space that the case that you're seeking does not yet exist, or maybe it's finding its way through the state or federal level.
Where you and I may disagree is the cases that I have seen all talk about actual children whose images are being manipulated one way or another. And so they're abused one way or another. But where I see some concern is the creative thought, no matter how sick. If it's not real world depictions of real world events, then it may well be protected speech. And so I'm trying to find from you the authority before we work this bill that lets me say, yes, this is constitutionally permissible. That's what I'm looking for, Mr. Kagi, and I haven't found it yet. It may be out there, but I'd sure appreciate your help, because without it, I may not be able to support this good idea.
I appreciate that, sir. And like I said, I'm happy to look into the issue. What I would add to that is, again, there are oftentimes situations where we have CSAM material. It's clearly sexual abuse, it's rape, and we don't know if that child exists in real life. We don't know where that child is. And so without the ability to hold that offender accountable, we're essentially condoning that conduct.
And hence, you can't prove beyond a reasonable doubt that a child was actually abused. You don't know one way or another.
Okay, we're going to move on.
Thank you, Madam Chair.
Yep. Mm-hmm. Any other questions? Representative Osmond.
Thank you, Madam Chairwoman. Representative Carmichael does bring about an interesting question, but let me try to take it from a different perspective then. This might get a little technical, but I guess the question is, so AI itself is a generative tool. It actually conglomerates data to spit it out in some form. Where is that data coming from? Where is that underlying data coming from? Is it made up whole cloth from one's imagination? Is it coming from previous child porn? Is it coming from real world examples of kids that are morphed? Is it some combination of the three? And maybe from a legal perspective, you might not be able to answer it, but I don't know technically if you know, or if somebody else as a proponent knows, where is the data coming from?
Thank you for the question. That is such an interesting question, and I do not have the technical expertise to tell you about the foundational steps for AI. Whether anything I say at this point would be speculation in that regard, but I do think it is a very interesting issue.
Any other questions? Mr. Kagi? Okay, thank you. Appreciate it. All right, now we'll have up Ed Klump from the Sheriff's Association, Chiefs of Police, and the Peace Officers Association. Thank you. Good to see you in committee.
Thank you, Madam Chair. I am Ed Klump for the three associations you listed, and want to express our support for this bill. In the weeks leading up to this session starting, I had several calls encompassing members of all three of the associations that I represent here, asking about this issue and whether it was something that needed to be fixed, which tells me we are running into these cases. I don't know the details of those cases, so I don't know if it was morphed images or what it was, but clearly we are running into these cases. It's unfortunate, but every time a good thing's created, somebody finds a bad way to use it, and that's what we're running into here with the AI stuff. And so this is an effort, I think, to rein this in on a very, very narrow problem of the sexual images and nudity and making people look like they're in a state that they really weren't in. And I think that's the bottom line. In my testimony about the middle of the page, where you see those indentations, I put in an example that I found on the internet in an FBI release about a particular case. You can read through that. And it just kind of emphasizes what we're talking about. I also found this document that's attached, I think, to my testimony. I actually found it after I turned my testimony in, so the committee assistant was very gracious to get that added to that. And it's a public service announcement from the Internet Crime Complaint Center of the FBI. And I'll point out in the first paragraph of that, it talks about sexual abuse material created within content manipulation technologies, to include generative artificial intelligence, is illegal under federal law apparently now. It doesn't cite the statute, but what it says. And then down at the very bottom of that page, it talks, very last couple of lines, used a web-based AI application. Representative Williams, you asked about the availability of those. Well, this case here was a web-based application that a person used to alter the images of actual clothed minors into sexual material. And then another issue that comes up that I don't think's been mentioned yet, in the middle of that section titled Recommendations on the second page of that document, it talks about this sextortion schemes. And that's where we see a lot of this impacting even the kids, is somebody will generate this stuff and then they'll use that generated image to threaten that person that I'm going to release this image to all your friends, to your parents, and all this if you don't do this or you don't do that. And that is a real issue. If you've ever looked at the suicide statistics for children, for youth, especially teenagers, many of those suicides were preceded by these kinds of activities, and the child ends up committing suicide over them. And so it's a real problem. It's a real issue. It's real in Kansas. Our people are coming to us and say, what can we do about this? And I was pleased when I saw the bill because of the calls that I've been getting, and it addresses those issues. So I can't speak to the legal stuff. There's plenty of legal minds in this room that can debate those issues, but that's the practical side of it we're seeing as law enforcement, and I'll stand for questions.
Okay, thank you so much. Any questions, committee? Representative Carmichael.
Thank you, Madam Chair. And Mr. Klump, the document that I was referring to during Mr. Kagi's testimony from the FBI, that was the document you provided. It showed up separately in my office, so I wasn't sure where it came from.
Okay.
But I appreciate you providing it, and you're absolutely right. This actual images or partial images of kids or people who are being blackmailed, we absolutely need to stop that. But are you aware of any, and I know you're not the legal expert, but my Lord, my goodness, you know a lot about crime in Kansas. Are you aware of any place where folks have been bad folks have been successfully prosecuted, not based on an actual image or a distorted image or a morphed image, but have been prosecuted successfully for just making up sick ideas on a computer? That's where I'm having difficulty with part of this bill.
And I simply am not in a position to have that familiarity level with the cases to know whether that's happened in Kansas.
I didn't mean to suggest that you should, but I kind of want to ask every proponent if they know of such a thing, because if they can, I'm going to feel a lot better about this bill.
Okay, committee, other questions? Okay, thank you so much. We now have Representative Brad Barron on our committee. Thank you for coming up to the podium.
Thank you, Madam Chair. Thank you, fellow committee members. So yes, and just to kind of give you where this bill came from, had an agency down south. And what had happened is, and I can't go into specifics, but there was a juvenile, a regular photo of a juvenile. And this sex offender, who happened to be a family member of this juvenile, used AI to manipulate it to fit the definition of sexually explicit conduct. And so that is where this idea came from. And so with that idea, I started talking to individuals on the prosecutor side. I started talking to FBI TFOs and other law enforcement officers who are in ICAC units, Internet Crimes Against Children, and found that this is an issue that's happening here in Kansas. So real quick, I want to address a few things, a few questions that have been asked in this committee. Where does this law currently exist? So talking with the FBI TFO I was in contact with, on the federal level, they do have the ability to prosecute this. I have not received that federal code yet, so I don't want to cite that. What I do want to cite for you today are 2 state statutes I do have in my hand. First is the state of Utah. Now, the state of Utah successfully passed this just last year in 2024. The reason why you're going to see all of these AI bills being passed 2023, 2024 is because AI, with just in the last couple of years, has gone insanely accurate. There are photos of people that you'll see on Facebook that look so real. Even a year ago, if you looked at AI-generated photos, you could usually tell in the eyes that something was messed up. Everything else looked legitimate, if you'd mess with AI at all. As we get closer now, there are so many legitimate, they look legitimate photos of adults and now CSAM, child sexual abuse material, and it looks so real. You cannot tell the difference. So real quick, citing the Utah statute, and this is the defining visual depiction under child sexual abuse material. So one, they talk about a real minor, right? So they say of a minor engaging in sexually explicit conduct. And then it goes to part 2, or artificially generated and depicts an individual with substantial characteristics of a minor engaging in sexually explicit conduct. The representative from Wichita quoted I believe it was, South Dakota statute, and I actually have that one with me as well. In the South Dakota statute, it says an individual indistinguishable from an actual minor created by the use of artificial intelligence or computer technology capable of processing and interpreting specific data inputs to create a visual depiction. Now, I would be more than happy to get an amendment to add that this is to that exact phrase. As you've seen, it's pretty similar in both of those statutes, but they do cover both AI-generated CSAM, whether in part or whole. So the question is, why do we want in part and whole, completely AI-generated? And you've already heard some studies about how those who are in possession of CSAM have more likely than not, gone hands-on with a child. They've abused that child. But I also want to tell you about an amazing training as a law enforcement officer that I went to in Maryland. This training was taught by a world-renowned psychiatrist who is from over in England, but he's interviewed hundreds of sex offenders and done detailed interviews with them, some 2 to 3 hours long. In his study and the data he's collected, he found one thing true. When these offenders decided to go hands-on with a child, beforehand, there was a cycle. This cycle started with them fantasizing and then acting on that fantasy. And it continues to cycle and cycle. And the wall that separates them from going hands-on with a child and staying in that fantasy gets smaller every single time. So that offender will fantasize about doing sexually explicit things or seeing sexually explicit things of a child, and then they'll act on it. What's that act? Usually it's masturbation or some other such thing. And they're using child sexual abuse material to do this, including this CSAM material. So when you do this and they continue to cycle and cycle and cycle, that wall, that border that says, hey, I can't go hands-on, I might get in trouble, just continues to get smaller, and they act on that. So that is one of the key drivers as well of why this legislation is so important. And then I do want to go over just a few more things. So, and I have some notes here, which is what I'm referring to. When you'll hear, and again, I'm not an attorney, I'm a criminal investigator. When you hear, well, this is protected speech when it comes to if it's fully artificial intelligence, it has been made clear in case law that protected speech is not sexually explicit material of a child. And to go further on that, let's read what the statute of Kansas describes. So if this were enacted, this would be an AI-generated photo of what, let's use a 12-year-old or a 13-year-old child, clearly depicted as a 13 or 12-year-old child, engaged in sexually explicit conduct. And so they have to be nude. There has to be sexual intercourse or sodomy, including genital-to-genital contact, oral-to-genital contact, anal-to-genital contact, or oral-anal contact, whether between persons of the same or opposite sex, masturbation, sadomasochistic abuse, with the intent of sexual stimulation or lewd exploitation of genitals. Nothing is artistic about that. That is sick, that is disgusting, and it depicts what looks like undistinguishably a real child. So I have no issue with if we need to do an amendment to add that language. But with that, like I said, we've seen some local cases here just south in my district, and I'm obviously a strong proponent of this and ready to answer questions when able.
Thank you. And would you tell us about your other representative, the other side of your life? You said you were an investigator, but just a little more detail about what you do.
Absolutely. So I am a criminal investigator, actually for the Shawnee County District Attorney's Office. So I started as a deputy sheriff and then came over to the DA's office 3.5 years ago. I've been blessed in that training to work with local, state, and federal law enforcement officers who all are either working human trafficking or child exploitation crimes. Obviously, those are intertwined. One part of my job is I have one of the only 2 dogs in the state that are capable of detecting electronics. They're ESD canines, and so with that dog, I've been on federal search warrants, helping assist look for digital material that's capable of storing digital data, as well as state and local law enforcement agencies. But I've been blessed in that position to go to training all across this country. I don't think I've ever had a training request turned down, and if you go to all of these experts from across the country, they'll all tell you the same thing, which is CSAM is a growing crime, and they're seeing it. I would also like to, the representative from Wichita mentioned the Wichita officer that is proponent testimony, that is testimony in favor of this bill. They did just say that, hey, maybe that language needs to be cleared up, which I am more than happy again to put an amendment on.
Okay, thank you. Representative Williams.
Thank you, and thank you for bringing this bill to committee. Okay, so just for my understanding, I'm trying to grasp my brain around all of it. Expanding the breach of privacy laws to cover AI generated or digitally altered images includes then, since it's altering, that would include revenge porn per se, so we're going outside of the child into the adult as well.
Yeah, thank you so much for bringing that up because I actually forgot to address that. So the third statute referenced in this bill is the breach of privacy statute. The breach of privacy statute has that clause for crimes like sextortion at the very end. So what you're seeing done here, and this is also what I've addressed in my letter, you'll have a normal picture of yourself. Someone will take that normal photo or that normal video and they'll use AI to make it look like you're in the nude and maybe doing something sexually explicit, and then they'll threaten you with that video and say, I'm gonna send this to all of your friends, or I'm gonna send this to all of your colleagues if you do not comply. And I wish I would have brought some of those statutes up, but there are states in our country that have similar statutes. I know New York is one of them. They updated their sextortion statute. So that's what it's addressing. And then to add on to that, so most commercially available AIs, if you have it on the app, are going to restrict you from doing some of this explicit conduct. The difference is these guys are pretty tech savvy and they're using AI platforms that may not be restricted. That's where you're seeing this material come from. And again, it's not just a child in the nude, it's a child in the nude doing sexually explicit conduct. So thank you.
Great, thank you. Thank you, Madam Chair.
Any other questions? Representative Carmichael.
Thank you, Madam Chair. A preliminary question. I'm not very good on acronyms. We have a retired FBI agent in the back of the room drawing a pension as we speak. But what's a TFO?
Thank you. That's a great question. And sorry for using acronyms. It's a task force officer. So a lot of work on the ground level is done by local police department detectives that have task force officer certifications. Thank you.
Gotcha. Let me ask you the same question that I've asked the other proponents. Are you able to point us to some case law authority where courts have found it to be constitutionally permissible to create electronically or even otherwise, or to prohibit the creation electronically or otherwise of the types of images that we're talking about here, as opposed to statutes which properly can proscribe the use or partial use of images of real children or morphing those images? You follow where I'm at here? And help me with this, because I'm looking for those cases.
And that's a good question, Representative, and thank you, Madam Chair. So I can only point to existing new statutes. Again, this is all what 2023, 2024. So a lot of these cases haven't worked their way through the courts yet. But there are at least 2 states I've cited that in whole, completely AI-generated CSAM is illegal. But again, this is so new. 2023, 2024, you're not going to see court cases yet.
We have the citation to the South Dakota statute. It's contained in the City of Wichita's written testimony. South Dakota described as South Dakota 22-24 small a-2. But we don't have the cite to the Utah statute, because I'm going to ask our friends at Legislative Research to retrieve these statutes and do what we used to call a shepherdization to see if those statutes have been applied and what the outcomes may have been. Do you happen to have the Utah statute handy?
Representative, that you've done your 2 questions.
I'm just trying to save the problem, just find out what he referenced.
I think it's a great idea that we do get more information, and probably Jordan will be able to do that. So thank you.
Could he at least tell us what the statute is he referred to?
You had your 2 questions, and so I think we're going to leave it at that.
Okay, we'll just do it the hard way, Madam Chair. Thank you.
Are there any other questions, committee? Okay, I do want you to take a look at the proponent testimony. Oh, sorry, is there anything else? Nope.
No, I do have the statute if you'd like it, but I can give it after.
That'd be great. Go ahead.
Yeah, the Utah statute is 76-5B-103.
Okay, great. Thank you. Thank you, Representative. Appreciate it. Okay, also written only proponent testimony from the Wichita Police Department. Sergeant Jeffrey Swanson. I think Marley brought it in for the Wichita Police Department. And just so if you're wondering why her name is on that, but do take a look at that written only testimony also. Okay, any other proponent testimony? Okay, then I will call up opponent Emily Brandt from BIDS. Welcome to committee, Emily. Thank you. Make sure that's on. Yep.
Okay. Like Madam Chair said, my name is Emily Brandt. I'm a member of the BIDS Legislative Committee. I'm an assistant appellate defender for the public defense system here in the state of Kansas. You have my written testimony. I'll try and address some of the things that were asked of proponents, and I'm of course happy to stand for any questions. With all due respect to the proponent testimony, this absolutely is a free speech issue. There is United States Supreme Court case law that says child pornography is not protected under the First Amendment. And then there is clarifying United States Supreme Court case law, Ashcroft versus Free Speech Coalition, that talks about the exact kind of issues that we're talking about today. In Ashcroft, the federal statute at issue criminalized any visual depiction, including any photograph, film, video, picture, or computer-generated image or picture that is or appears to be of a minor engaging in sexually explicit conduct. We have that exact same appears to depict or purport to depict language in HB 2183. The United States Supreme Court found that that language is unconstitutional. It infringes on people's free speech rights. And again, with all due respect to proponent testimony, one of the arguments raised is CSAM is absolutely used to groom children. We have to prohibit it in any form. That exact same argument was raised by the federal government in Ashcroft, And the United States Supreme Court explicitly said that that was not good enough. The federal government argued that this kind of material whets the appetite of pedophiles. But this argument falls short of constitutionality. You cannot punish people. You cannot infringe on their rights to free speech because free speech might encourage them to later do unlawful acts. We might not like virtual child pornography. It might be offensive to us. That does not mean that we have a right to tell other people that they have no right to it. And we can't criminalize people for something they have not done. You can't criminalize this kind of material just because users of this material may then go and commit crimes. I also heard testimony all about morphed images. This is already prohibited by statute. We have Kansas case law on this, State v. Coburn. It's a Kansas Court of Appeals decision. It directly addressed the Kansas sexual exploitation of a child statute when it comes to morphed images. The Court of Appeals held that simulated or morphed images of real children are not protected speech because they harm real children. This bill doesn't do this. This goes beyond that. We are talking about material that frankly doesn't harm any real children. And if it doesn't harm any real children, then the United States Supreme Court says that you cannot criminalize it. And when we talk about free speech rights, it is very severe to trample on speech by criminalization. You cannot put people in prison for their free speech rights. And I think that to the representative from Wichita's question, I don't think that any of the proponents can find case law that supports their position. Ashcroft is still good United States Supreme Court case law. It is still binding case law. And I frankly heard the proponent, the DA from Shawnee County, say that this conduct is already prescribed. This already is prohibited by our statutes. What is AI if not digital, if not electronic, if not et cetera? There's no reason to expand this bill except in ways that is unconstitutional. And I think frankly the statutes that have been discussed probably are likely unconstitutional under Ashcroft versus free speech. I think that even the South Dakota statute that talks about, well, we can't distinguish between what is totally artificial and what includes real children. That argument was also brought up in Ashcroft by the federal government. And again, the United States Supreme Court says that this kind of argument falls short of being constitutionally valid. A government can't ban protected speech as a means to ban unprotected speech. Any suppression of lawful speech violates the First Amendment, particularly when that suppression criminalizes the speech. It imprisons people for their speech. It's always the state's burden to prove a crime beyond a reasonable doubt. This kind of unconstitutional change to our statutes makes these kinds of crimes strict liability crimes. It relieves the state of a burden to prove that actual children were harmed. And the defendant can't put on an affirmative defense that there were no real children harmed in the materials that I possess. And frankly, again, with all due respect to the proponent's testimony, we talk about this having no sort of artistic or scientific or literary or whatever. But in Ashcroft versus Free Speech Coalition, the United States Supreme Court says they absolutely could. Again, that's not for us to decide. It's not us as individuals who get to decide for other people what is artistic, what is scientific, what is literary, what has value as speech. It may be very offensive to us. We may never want to look at that kind of material. We may never want to possess that kind of material. That doesn't mean other people don't have the right to. So I'm very happy to stand for questions, but we would strongly urge you to oppose this kind of legislation in light of the fact that we have binding United States Supreme Court case law that says this exact kind of legislation is unconstitutional under the First Amendment.
Okay, thank you, committee. Do you have any questions? Representative Barrett.
Thank you, Madam Chair, and thank you for coming to committee. I guess my first question would be, when Ashcroft was decided, it was because law was overly broad. And again, AI was not around during that time. So when you look at AI is taking mass amounts of data and putting it together. So when it's creating a juvenile, it knows what a juvenile looks like because that's what the data all this data it's gotten resources from has been collected. In addition to that, it has to fall under the specifics of what exploitation is. There has to be those lewd and lascivious acts, and I'm sorry, even worse than that, there has to be these very sexually explicit conduct. How is that narrow? Or how is that not narrow, according to Ashcroft?
I mean, I think thank you for your question, and Madam Chair. I mean, my first response to that would be prove it. It's the state's burden to prove that a crime has occurred. If you think that AI is using data sets that include real children, prove it. And then we already have the crime. You don't need to expand the definition of sexual exploitation of a child to convict an offender of the conduct you're talking about if you can put on evidence that the AI generated this image and used real images or videos or whatever of children. I mean, again, I'm sitting here and telling you that this state has this burden to do this. We can't alleviate the state of its burden because it's hard. That's not how the criminal legal system works.
Go ahead.
Thank you, Madam Chair, and thank you for that answer. My next question would be, you mentioned there has to be a real victim. Many times, many agencies, when it comes to child exploitation crimes, will do predator stings. And what happens with predator stings is we will have an adult who, using technology, is made to look like a juvenile. That juvenile will post an online ad, and individuals will reach out and then try to meet that juvenile. That person will then be arrested for attempted exploitation of a child. Now, that doesn't involve a real victim. That's just a police officer pretending to be one. How is that any different?
Thank you for your question, Representative. I mean, a couple of things. Again, we're talking about morphed images. You've taken an image of a real person, you've morphed it to look like a child. So there is a real victim. It might be an officer, whatever, but there is a real person on the other end of that morphed image. My other thought would be, again, we're talking about attempts. They're not as severe as the completed crimes, et cetera. And I think my other point to that is, under United States Supreme Court case law, it says that there need to be real, actual children at the end of this. So I guess we could start challenging those sting convictions as well. But right now, the United States Supreme Court case law is very clear that if there are not real children being used to produce this kind of content, and that's because in Ferber, that's United States Supreme Court case law that said child pornography is not protected speech. And in Ferber, the reason it's not protected speech is because we're not actually talking about the content. We're talking about the production and the fact that it harms children. And states have a very legitimate interest in protecting children from harm. And the reason that Ashcroft is different, the reason that it did not fall under the Ferber standard is because now we're talking about content. Now we're not talking about the production of materials because it doesn't include real children, real harm to children. So again, I would challenge members of this committee to find any case law that supports this kind of legislation because right now it doesn't. The United States Supreme Court is clear.
Thank you, and I've asked my second question.
Yep. Representative Lewis.
Thank you, Madam Chair, and thank you for your testimony. I'm interested in if I understand your reading of Ashcroft and progeny. Is it your position that if an image, regardless of how sick it might be, has any artistic merit, that it therefore is protected by the First Amendment?
Thank you for your question, Representative and Madam Chair. That's my position, yes. Again, how sick it is subjective. So I don't think that it is for this group of people, for any one person, to say what is and isn't speech when it's clearly protected by the First Amendment.
Respectfully, I've studied those cases, and it's clear to me that you can have art that's also pornography, and it's not protected for that reason. Thank you.
If I may briefly respond.
Go ahead.
My response to that then, Representative Lewis and members of the committee, is that you should look into including the obscenity requirements from California v. Miller. If you think that an image or this kind of material is so sick that nobody can have it as speech, then I think that the statute needs to clearly say that it's some kind of obscenity material and that it meets those constitutional definitions of obscenity under California v. Miller.
Committee, other questions? Representative Sweeley.
Thank you, Madam Chair, and thank you, Mrs. Brandt, for being here. I'm kind of confused on the real victim kind of identifier, I guess. So if you said you took a 10-year-old girl, right, and she was naked and you took a photo of her, right, would you consider that a real victim?
Representative,
No, no AI. If I took a picture on my phone.
yes.
Okay, so what is the difference of her face being on a naked body? You would say that's not a real, or an AI generated naked body, but her face. That's not a real victim.
Representative, well, that is a real victim because that's a morphed image. You have taken, I believe, an AI-generated naked body of presumably a child, and you've taken this real child's face and you've put it on this AI image. Am I understanding your hypothetical correctly?
Yes.
Okay, then yes, that is already criminalized under the statute. That is considered a morphed image. It's not totally made up. You have a real child whose face you have taken and put on an image, and morphed images of that characteristic are not protected speech. And again, in State v. Coburn, which is our case law, that's already criminalized. You don't need this legislation to criminalize that.
And if there's any sort of AI or anything generated about that person's face or their identity, what would you consider it? Say like if their hair was a different style or if they had makeup on, whatever you want to say.
Representative, again, if it's any sort of morphed image of a real child, that is one, already prohibited conduct under our statute, and two, a morphed image and not totally made up, not appears to be, purports to be, et cetera. There is a real victim there, and it's already criminalized.
Okay, thank you.
Representative Carmichael.
Thank you, Madam Chair. Ms. Brandt, I very much appreciate you being here today. I know that the defense of those who have been charged with heinous crimes is not an easy thing to do, but we all recognize it's an important part of our system of justice. I'd like to direct your attention, for purposes, though, of my question, to a case, United States versus Williams, which was decided let's see, about 3 or 4 years following Ashcroft. And in Williams, the court describes its holding in Ashcroft, and in very summary fashion, they said, page 289, the broad authority to prosecute child pornography is not, however, unlimited. 4 terms ago, we held facially overbroad 2 provisions of the Federal Child Pornography Protection Act, citing Ashcroft. The first of these banned the possession and distribution of any visual depiction that is or appears to be of a minor engaging in sexually explicit conduct, even if it contained only youthful-looking adult actors or virtual images of children generated by a computer. Skipping the citations, this was invalid, we explained, because the child protection rationale for speech restriction does not apply to materials produced without children. Is that still the law?
Representative, Madam Chair, yes.
Thank you.
Anyone else? Okay, thank you. Appreciate it.
Thank you for your time.
Yep. Okay, committee or audience, anyone else, proponent, opponent, neutral testimony on House Bill 2183? Okay, we will close the hearing on House Bill 2183. Thank you all. And we're going to go ahead and work our first bill. We're going to, hang on, do... I can't find my agenda. Here we go. We're going to go ahead and work House Bill 2061. And Jason, if you could just give us a quick reminder of what that is about.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. As you may recall from the other day, House Bill 2061 is the bill that adds above ground and below ground lines, cables, and wires to the definition of critical infrastructure facility in the crime of trespassing on a critical infrastructure facility and criminal damage to a critical infrastructure facility.
Okay, thank you. Do we have a motion on House Bill 2061? Representative Williams.
Thank you, Madam Chair. I move that we pass out House Bill 2061 favorably for passage.
Do we have a second? Representative Schreiber seconds. Okay, we can talk about this bill. Any questions or amendments on this one? Representative Williams.
Thank you, Madam Chair. I do have a balloon amendment, which Jason will pass out. This was discussed in committee. AT&T spoke as a proponent of the bill, but also requested to have cell towers, small cell wireless facilities, and equipment cabinets included. They also highlighted the need because they were having issues that Charter Communications listed, but also to illegally remove copper cable as well. So I have talked to Charter Communications, and this is considered a friendly amendment.
Okay, and is that a motion?
I move my motion.
Do we have a second on the amendment? Representative Goddard. Okay, discussion first on the amendment committee. Everyone clear? Any discussion on that one? Okay, Representative, you may close.
Thank you. I close.
So you've heard the amendment, the Williams amendment on House Bill 2160. All those in favor say aye. Opposed, no. Okay, the amendment is now put on the bill. Okay, any other discussion or amendments for House Bill 2061? No? Representative Williams, you may close.
Thank you, Madam Chair. I move House Bill 2061 as amended favorably for passage.
Okay, committee, you've heard the motion. All those in favor of passing House Bill 2061 as amended favorably for passage, say aye. Opposed, no. Okay, we have our first bill passed out of committee. Congratulations, Judiciary Committee.
Madam Chair,
Yes.
I ask that my affirmative vote on the amended bill be recorded in the minutes.
Okay, thank you. Anyone else would like their bill, their vote recorded? Okay, we will make sure we do that. You're welcome. Okay, committee, wow, enjoy these 15 minutes because I don't think you're gonna, maybe this week a little bit, but next week we probably won't have a lot of extra time. So enjoy getting out at 4:45. Anything else for the good of the committee? Okay, thank you so much. Good work. We're adjourned.